I'm sure all of us have heard the term lien before, but have you ever had work done on your house and wondered why are liens being brought up and what protections do I have as a homeowner? Or maybe you're a contractor and you're wondering what rights you have as well. I'm Paul Zimmer, a real estate attorney who services all of Wisconsin. In this video, we're discussing something that homeowners and contractors alike need to understand: the construction contractor lien process here in Wisconsin. If you're a homeowner and you've had construction work done, or you're a contractor that completed work, you need to know your rights and what happens if payment is not made. Let's break it all down. First things first, it's important to know what type of construction project you're dealing with, because the construction lien laws vary depending on whether your project is a public or government project, or whether it's a private project. It also depends on whether the project is a large project, such as a commercial property or a residential property with more than 4 living units, like an apartment, or whether your project is a small project in comparison, like a residential property with 4 living units or fewer, such as a regular house or a duplex. In addition, it also matters whether the project is bonded or not bonded, which means whether or not the contractor has furnished a payment bond as part of the contract. This video is going to focus only on small, private, non-bonded projects, which are the type of project that most everyday homeowners and home remodeling contractors deal with when homeowners hire a general contractor for regular repairs or remodeling. That said, if your project falls into one of these other categories I mentioned, you can still feel free to contact our firm and we'll still be able to assist you. Now, with that out of the way, the next thing to know about construction liens is the requirement that the general contractor provide advanced notice of the lien laws if the contractor intends to utilize any subcontractors, suppliers, or service providers on the project. The contractor must include the written notice in the contract, or if the contract is verbal, the contractor must provide a separate written notice. That notice should explain that the contractors, subcontractors, suppliers, or service providers will have lien rights for the work or materials that they provide to the project. So, what happens if a contractor isn't paid and decides to file a lien? Well, you must be notified, and a lien must be filed within 6 months of the last work or materials that were provided at the project. If they don't act within that time frame, they forfeit their right to file a lien. So timing is critical both for the contractor and for you as the homeowner. To make matters more complicated, the contractor must provide written notice of its intention to file the lien at least 30 days before filing the lien. This means that the contractor can't wait the full 6 months before starting the process. The contractor must also provide a notice of the filing of the lien within 30 days after filing it as well. Further, for all of these notices, it must be served by at least registered or certified mail or by hand delivery. A regular letter in the mail, an email, or a text message would not suffice. If a lien is properly filed, that does not mean that the contractor automatically gets your property. It simply means that the contractor now has the legal right to file a foreclosure lawsuit unless the debt is paid. In other words, the contractor can force the sale of the homeowner's property to recover what they're owed, but they must file that lawsuit within 2 years of filing the lien. Further, it's not automatic. The homeowner may contest the contractor's claim in that lawsuit by arguing that the funds are not owed. Ultimately, lien laws are rigid and strict compliance is necessary. Keep in mind that even if a contractor doesn't properly pursue a lien, the contractor could still sue for breach of contract within 6 years of the breach, and a successful judgment after a lawsuit would still act as a lien on the home. So if you're a homeowner or a contractor in Wisconsin and you're dealing with a lien or have any concerns about the contractor lien process, we are here to help. Whether you need assistance understanding the law, filing a lien, challenging a lien, or negotiating a construction dispute, don't hesitate to call your friends at Zimmer Rens. Also, please take a moment to subscribe to our channel for more videos on real estate law, nationally and locally here in Wisconsin. And if you have any questions or need assistance, leave a comment below or contact us directly. Thanks for watching, and we'll see you in the next one.